Good afternoon, everyone. I am Advocate Rathi, Managing Partner at Lexidem and Rathi, and founder as well at latest.com. I would like to welcome our viewers and our distinguished panelists to today's Lexidem webinar on SM International Commercial Arbitration and its challenges. Today, we are highly privileged to have with us Professor Loukas Mistelis, who is a professor and former director of School of International Arbitration, Queen Mary University of London. He has extensive experience in international arbitration practice, having been appointed as arbitrator in ICSID, LCIA, SCC, GCC, Swiss Chairman ad hoc rules. Professor Loukas is also visiting faculty in several renowned universities around the world. Welcome, sir. Next, we have with us Mr. Sarosh Zaiwalla, sir. He is senior partner Zaiwalla and Co-Solicitors, London. He is his firm's founder and senior partner, overseeing all the firm's activities. He began his career in law and arbitration, then branched out into other types of arbitration. Over the years, he has been involved in more than 1,200 international litigation arbitrations in different fields like energy, maritime, construction, either as solicitor, counsel, party-appointed arbitrator, or sole arbitrator. Sir has acted for a wide range of clients, varying from President of India, Government of China, Iranian government, to celebrities like Amitabh Bachchan in India as well. I would like to express my deep gratitude to the panelists for joining us to the webinar. The moderator for the webinar is Mr. Govind Gehlot, partner K. Gehlot and Associates. He is an alumni of Queen Mary University of London. The webinar is also being telecasted live on Latest Law's Facebook page. There will be a question and answer session at the end of the webinar, and the users can send their questions through the question and answer facility available on their screen. Now I would like to ask Govind to welcome the panelists and carry forward the proceedings.
Thank you, Divyanshu, for such a warm welcome. And thanks to latestlaws.com, who is very helpful in organizing this webinar for today. A very good evening to all the viewers who have joined us today. Special thanks to Professor Loukas Mistelis, to Mr. Sarosh Zaiwalla, sir, for this webinar and joining us today with all these happy faces. And now I would like to introduce with our webinar session. Our webinar session has been divided into two parts. Part one deals with the basic aspects of international commercial arbitration, which will be covered by Professor Loukas Mistelis, and part two touches the practical sides of international commercial arbitration, like judicial intervention, enforcement of foreign awards, and post-COVID effect on arbitration proceedings, which will be addressed by Mr. Sarosh Zaiwalla. And now I would like to invite Mr. Loukas Mistelis, sir, to please address his comments on basics of international commercial arbitration. Professor, you may please proceed.
Yes, thank you very much. I'm delighted to be joining you today and have an opportunity to address a couple of issues that relate to trends in arbitration, looking particularly issues of applicable law and what happened in the various seats and various institutions. I have about 25 minutes at my disposal, so I will inevitably be quite selective in what I'm covering, but of course I'm here for the discussion time afterwards, and feel free to address questions as we go along. I'm going to be now sharing my screen, which will give you an opportunity to see the slides I have prepared for this session. So there we go. And a couple of very basic ideas which I think are quite important. Let's not forget that arbitration is an interesting creature. Everything in arbitration is about choice. The parties can always have a right to go to court. Arbitration is a right which is exercised as a result of choice. So you made a specific choice to go to arbitration. And for arbitration to operate effectively is critical for all participants to have confidence in the system, and they have trust in the adjudicators they have selected to adjudicate the dispute. At the same time, of course, arbitration is very much relating to autonomy, is largely self-policed by the tribunal, and the interaction between arbitration and court is quite minimal. It only happens as and when it is absolutely necessary. But there is quite, of course, of interaction between arbitration and courts. I think about 70% of the cases that go to the English commercial court have some aspect of arbitration in the background. It's either enforcement proceedings, setting aside, challenges, interim measures, and that is about 300 cases a year. That out of arguably about 20,000 cases that are being arbitrated every year in London. So last not least, when people, of course, exercise their discretion, arbitration is about quality. For arbitration to operate and to operate successfully, it is critical that parties have the sense that the process is one of quality and perhaps as good, if not better, than national courts. The second important peculiarity of arbitration is that arbitration operates horizontally. All of us who have been to a court of law once or twice, or perhaps sometimes much more than that, we would notice that the judge is elevated, sits at the bench, and the rest of the parties, the litigants, are a few steps below rather. So in arbitration, however, we don't have that idea of an elevated bench. Everything in arbitration is horizontal. The tribunal is at the same level as the lawyers for the claimant and the respondent, and at the same level as the parties themselves. And of course, it's the parties that give to the arbitrators the power on the basis of their agreement. So I think the first word I've said is arbitration is all about choice, and I would like to address this issue of choices a bit. Arbitration operates well when things are working very well. And when we started looking at what is the situation amongst users of arbitration, and we did the first research of that type about 15 years ago now, we realized that one of the key concerns was cost, and it was followed by the question of delays. So we traced that debate 10 years later in 2015, and while the cost in 2005, 2006 was the concern for about 50% of the arbitration users, it became 70% in 2015 and dropped to 67.4% in 2018, 2019. So cost and the way arbitration operates, particularly in civil law jurisdictions, so particularly from the perspective of civil law jurisdiction users and of users from developing countries, is that arbitration is relatively costly in relation to what they would spend for domestic court proceedings. Of course, one can see the perspective of costs in so many ways, and of course we should not forget that arbitration is a one-stop shop. You don't have appeal, you don't have a cassation or another level, so all the cost is spent in one single matter, and of course a lot of arbitration cases are much more complex than domestic cases. If there's one reason that justifies the cost of the arbitration, is that arbitration is a private process, and therefore the times when people used to travel quite a bit, for example, arriving to London, they will arrive to Heathrow Airport. So going to court is like taking public transport, taking a bus or the London Underground. You know that within an hour and a half, and for £4-5, you will get to the centre of London. It's not going to be very comfortable. It's going to be very packed. You don't have space for your luggage, and you cannot dictate the route. Arbitration is not taking the underground, not taking the bus, but taking a taxi or taking a limousine service, where you decide who is going to drive you, which route you're going to take. Of course, this is always a bit more expensive, and it's a bit more comfortable, and it's actually very much organized to the level that the parties will want. That effectively justifies the extra cost in most cases, plus, of course, the enforcement capabilities that arbitration has, which are much better than any court decision. Of course, the other issues of concern over the years are that parties start feeling now that tribunals do not have effective sanctions against dilatory parties in the arbitration. So the side effect of what we call as the due process paranoia. Tribunals are particularly concerned about rendering an enforceable award, giving the parties every possible chance to present their case and to raise objections and deal with whatever they have to deal. But that has the consequences very often that we are in a situation where we are not aware exactly we should be in the circumstances of the case. And that, of course, has the consequence that this complication has become quite prevalent. So the lack of power in relation to third parties as well, which is, again, the broader power of tribunal, is also the other aspect which comes across very, very much. Speed, from what you see, has become a less of a critical issue. And that's perhaps where we are moving now. So arbitration is still being used because the advantages overpower the disadvantages. So when one then chooses arbitration, one of the very important questions is to choose the appropriate seat. And in 2019, as in 2015, and indeed as in 2005, London comes as being the most popular venue, followed by Paris very closely. Singapore and Hong Kong are also very prominent, and then we have Geneva, New York, Stockholm, and so on. So the trend we have seen over the last 15 years is that Asian centers have gained very much in terms of significance, and particularly with an impact of taking cases away from Europe and from the United States, while London and Paris still contain that significant role that they have always had. So it's good to bear that in mind. Of course, Geneva and Stockholm have a very significant portion of the case. One thing I wanted to show to elaborate a bit on that basis, if we look at London, Singapore, Hong Kong, and New York, which are places of significant sort of importance in arbitration, they're all common law jurisdictions. In other words, seats in venues which have a common law court in place to support, they appear to be very, very popular. Of course, Paris, Geneva, Stockholm are civil law jurisdictions, but overall, common law courts and common law jurisdictions fare much better. And that perhaps has to do very much with the support that the local courts can operate. Perhaps we should mention that between 2005 and 2011-12, where Paris perhaps has kept its importance, changed the local arbitration law for domestic and international arbitration proceedings and allowed French courts to provide support in the context of arbitration. But the other thing that is important to look, if we look at why particular seats are being chosen, the reputation and the recognition of the seat is very important. The neutrality and the impartiality of the local legal system is also very important, as it is the national arbitration law and the track record of enforcing agreements to arbitrate. You don't want to go to a court that would block your arbitration. You want to go to a court that is going to enforce your arbitration and agreement and send you back to the arbitration. And of course, efficiency of local court proceedings and all of these matters are important. So this trend has been similar to in 2015 and has been sort of very much across the lines of what we have seen. What very interestingly seems to be dropping slowly is that parties go to an arbitration seat simply because the lawyer told them that, or because the counterpart imposed that particular place. So there's a bit of much more conscious decision in choosing a seat, and that's a very good way forward. It seems that commercial parties are much more informed about the arbitration process and much more aware about the things that need to be doing in this respect. I think in this question it's also important to see how arbitral institutions do, and in the context of the current pandemic, institutions had to be very flexible, and in so many cases, institutions collectively published guidelines about online hearings, published joint statements, 12 leading institutions. But of course, arbitral institutions are a very important factor of the arbitration process. And in my experience, there are more cases perhaps going to institutional arbitration than they go to ad hoc arbitration, where the parties have to do everything. Although ad hoc arbitration, it does exist in certain contexts, particularly when the amount in dispute is very significant and when the parties are very sophisticated. But interestingly enough, this continuum, which is extracted by Remy Gerber's book on the functions of arbitral institutions, shows the level of interventions that institutions saw in the early arbitration phase. So, and you will see that the big institutions, the ICC, the LCIA, the American Arbitration Association, the Swiss Chambers, Stockholm Chamber of Commerce, are somewhere in the middle. And you have institutions which are much more active, like CTAC, and so the Moscow Arbitration Center, which are on the one end, and a bit of less sort of hands-off institutions like the Cairo Regional Center, Singapore, Hong Kong, Milan on the other end. It's interesting enough that the parties very much operate in the middle, where they think that a regulated, reasonable intervention is what is perhaps best needed in the circumstances. So you choose your seat, you choose your arbitral institution, but then you have to deal with a number of laws that are relevant, particularly when the arbitration is not all linked to a particular jurisdiction. In London, for many years, about 1/3 of all arbitral cases had to do with parties from the former Soviet Union and the CIS states. But these parties, although they have had a dispute between Russian parties, or Russian, Kazakh, Ukrainian parties, have had an arbitration agreement in favor of London and in favor of LCIA, which of course would make a share purchase agreement or an intra-corporate dispute an international matter. Now, in the majority of cases, what we have as an experience is that when we look at law, we have to look at a number of different aspects of the law. We have to look at the law governing the contract, the substance of the dispute, the merits of the dispute, as we often say. And in practical terms, about 90% of the contracts have a choice of law. That is very good. So that means eliminates the need for conflict of laws to about 10% of the cases, but there's still about 10% of cases where the parties have not made such a choice, and where we need to think about what would work and how that would work. But that is the determination of the rights and obligations of the parties. It's not the law applicable to the procedure, it's not the law applicable to the jurisdiction of the arbitral tribunal or to the arbitration agreement, and it's not the law that relates to the enforcement. We have all of these laws which are relevant. I generally find that the topics which are a bit more controversial is either the lex arbitri, which I think is an element of confusion for many inexperienced arbitration counsel, but also the law that relates to jurisdiction and the arbitration agreement. And many of you might have seen that the Court of Appeal in London handed down a judgment on the 29th of April 2020 on a matter that related to an application for an undersuit injunction to stop court proceedings in Moscow in the context of it. And it's very interesting that in this case, the English courts had an opportunity to look about the proper law of arbitration agreements, the form to bring such challenges, and a lot of different matters. So it's a very live issue and therefore a very important issue. Now, when it comes to the law either governing the marriage or governing the procedure or jurisdiction indeed and the arbitration agreement, an added complication is that in arbitration, the regulatory web has a strange density. We look at domestic law, we look at international law, for example, the New York Convention, which deals with certain aspects of the validity of arbitration agreements, but also the enforcement of awards. And what is also very, very important is what we describe as practices and soft law. Very many arbitrators will be doing things because that's the way they're used to do things. In a case very recently, the arbitrator said, we want to have pleading style submissions. We don't want to have traditional arbitral submissions. Of course, in that case, all of the counsel understood what pleading style submissions meant, but there will be cases where that needs to sort of familiarize one party, or perhaps both parties, what this type of summary submissions would be. And we also have other elements that come into play. Public policy. What is this public policy, and what is the element of mandatory rules? Because every choice of the parties ultimately will be controlled by the application of the appropriate mandatory rules, and will also be controlled by public policy at the seat of arbitration, but also public policy at the place of enforcement. And public policy is one of these sort of threads to the arbitration process. It's something that, despite multiple efforts, has never been properly codified and properly harmonized, and is one of the mechanisms that one can use in order to perhaps block the application of a particular law or block the effects of an arbitration agreement. So generally the view should be taken is that when it comes to arbitration, public policy should be looked at in a narrow fashion rather than in an expansive fashion, and that would allow the process to run, and then whatever is to be controlled, it will be controlled as necessary by national courts. So going back to this layer cake I described, so enforcement is at the law of the place of enforcement. That will be understood as it is a law which is most likely these days in accordance with the New York Convention 1958, or even perhaps less liberal. Questions of jurisdiction or the arbitration agreement is either the agreement of the parties or the choice of the arbitrators when the parties have not made an express choice, because we should not assume that the law governing the contract is also the law governing the arbitration agreement, and it's very, very rare that the parties make a particular choice of law to govern the arbitration agreement, and this could impact on many issues, for example, on the relevance of third parties and how far this arbitration agreement can reach, who are the real parties, and how far can we extend the process. On the issue of procedure, because of separability, as we know, we have either an express choice of the parties, the arbitration rules, or the practice, and again, in substance, in most cases, it will be the law chosen by the parties or whatever law, public international law, would have liked to do. Will guide us to. In terms of lex arbitri, and in that conundrum, lex arbitri, and given the autonomy of the arbitration process and the control of the parties, often has two dimensions. The traditional English case law looks at lex arbitri as the law of the supervising court, the law that organizes the interaction between the arbitration tribunal, the arbitration process, and the supervising court. But the reality is that lex arbitri has two dimensions, has an internal dimension, how the proceedings will be organized, how the proceedings will be conducted, and has also an external dimension for these perhaps less than 10% of cases where there will be an interaction between the arbitration process and the national courts, and that is the external lex arbitri. So the internal lex arbitri is very much in the hands of tribunal and covers the majority of the process, the organization, the contact, the experience the parties were going to have about the arbitration, while the external is how that process is having an outside life and what is this outside life. So that's where I would like to sort of stop, making sure that I'm not exceeding my time, and perhaps comment to you, perhaps it will come in the discussion, to look at this case that I have mentioned, the NCA and CHAB of the 29th of April from the Court of Appeal in the UK, which we might discuss a bit later as well. Thank you.
Thank you so much, sir, for providing such a profound knowledge about the subject. And now I would request Mr. Sarosh Zaiwalla to please put forward his views on the topic of practical aspects in international commercial arbitration. So you may please proceed. So the first question, which will be, is about the judicial interventions. What is judicial intervention and what are the grounds for such intervention?
First of all, thank you very much for inviting me. And I also thank Professor Mistelis for the honor of being in his company. I will slightly revise the topic, and I would say judicial intervention. Better thing is judicial supervision. And one of the reasons why London became the center of international arbitration is because there is a judicial supervision. And I believe that there must always be at least one layer of judicial supervision, because experience has shown that there are cases where the arbitrators sometimes have interest, there is conflict. So at least if there is one layer of supervision, the arbitrators are kept in check. Now, so what I'm going to do is to share my experience over the last 38 years of handling international arbitration and my experience as a member of the International Court of Arbitration of the ICC Paris, where I had India's seat for 12 years. And what I propose to do is to make it more interesting, to take you through the cases, particularly India-related cases, of how a potential misconduct could occur. And therefore, unless there is a provision where a party can approach the court for relief, I'm going to take you to three very interesting cases, starting from my early days. They're all reported cases, and they also find the reference in my book, the book of my memoir. The first case discussed the maritime. It's a different arbitration, where arbitrators arbitration. There were and I appeared myself before the arbitrators, and within 15 minutes, the arbitrators made an interim award of $100,000. So there is no defense, and this was incidentally this.
Your internet is not a bit poor. The internet connection is not working fine.
What do I do? Start again?
No. It is showing red on the meter, I think. So is your internet fine? The bandwidth is saying it is low.
No, but because I'm at my country house, which is by the seaside.
Oh, okay. Now it's fine. Continue, sir. Now it's better.
Yeah. I'm going to come back to the Costas Melis, and I made an application for misconduct against a very eminent maritime arbitration tribunal that came up before Mr. Justice Koff. The hearing went on for 3 days. It was the first ever case of interim award. And the judge reserved his judgment. And the arbitrators got so upset that they fixed a final hearing within 2 weeks. So I made a further application for misconduct, a second application, which was argued by Mr. John Hobhouse, QC, a very eminent. And the arbitrators, Mr. Justice Koff, at the end of that hearing said, judgment at 5:30 if I must, and all the arbitrators resign. But when their judgment was given, and this is what the court said, which is very important for all arbitrators to keep in mind, no tribunal can necessarily conclude his work with 2 satisfied customers, but it can be done. And experience has shown that for this purpose, it's sometimes desirable to give party a little more leeway than he may strictly be entitled to. The price of such an action is often small, and the price is large. With all respect, it is a point which the arbitrators might well do long. Now, this is just the first example of misconduct. The second important example which I'm going to do is a case called the Steel Authority of India, where the Indian participants in this webinar will know the Counsel for Steel Authority of India, Indian government, was Ashok Sen, who became the Tree Minister for Justice and the Tree Prime Minister. And the tribunal's chairman was Mr. Lotopak QC, who was an eminent professor at Cambridge University. The award went against the Indian Oil Corporation, came to me, we challenged. It was ultimately set aside. And what the court said, that I just for a minute. Okay. Okay. What the court said, setting aside the award, because there was a transcript for the hearing and there was complete misunderstanding. Mr. Sen, a very senior counsel, Mr. Lotopak QC, it looked as if they immediately could not hit off. And the judge setting aside the award said, however, the function of any tribunal is to separate the wheat from the chaff and endeavor to arrive at a fair and just conclusion, notwithstanding the lack of assistance they may be getting from one or more of the parties representative. So you see the necessity to go before the court for supervision in case an arbitrator misbehaves. There's a general belief now that the court must not intervene, but from my experience of handling over 1,200 international arbitration cases, I think it is very, very necessary. And the third case I'm going to, interesting case, was an award against Indian Oil Corporation of $18 million. The case is Indian Oil versus Coastal Bermuda, where three eminent arbitrators, eminent Queen's Counsel, one of them was Gordon Pollock QC. The award went against Indian Oil, but look at the honesty of the arbitrator. He, in the postscript of the award, and this was an arbitration that parties had agreed under in Arbitration Act 1996 not to appeal, so there can be no challenge. Gordon Pollock did a postscript effectively saying that, look, the Indian Oil has lost because the counsel legal team was incompetent. And this is an unusual case. And he said, I wish to record my regret that the sellers, Indian Oil, had not at some stage broadened the scope of the case. And he ends it by saying the results, I believe that the sellers had a far stronger case and they allowed themselves to advance, one of which might well have succeeded had that been formulated differently. What happens then? The Indian Oil came to me and said, sir, we don't mind being lost, but with this comment that we were incompetent, our heads will be chopped off. I went to two Queen's Counsel, they said, absolutely no chance, forget it. So I took a completely different ground of public policy, the English judicial public policy, that this award would be given leave to enforce. If this award is given leave to enforce, then the court will be giving leave to enforce a decision which is not based on a true legal analysis of the evidence. Once again, to everybody's surprise, we succeeded. Mr. Justice Evans said, finality is good, that justice is better. And throughout my practice, the most important principle which I have kept in mind is that law is for justice and not justice for the law. And therefore, you can play with the facts, but never with the law. Now, there are other cases which I'm going to refer to, which are so important. And the most important cases which will be of interest, which has some bearing on the UCOS award, is a case called PEC versus Asia Golden Rice. Again, it's a reported decision. In this case, PEC, 100% Indian government company, this was only about 5 or 6 years ago, got an award from GAFTA of $8 million against PEC from the claimant, a Thai company. PEC appealed, the award was lost. GAFTA has its own system and the award was lost. Then they came to me and they said it was a very unfair award, and we took a completely different. And the point which I took, the ground which I took to challenge the award under Section 67 was, and that was because for many years I'd acted for Indian government in London in the international arbitration cases, was that although the contract was signed on the soil of the Republic of India, and under Indian law for government contract, you require two signatories, a director, and not just the chairman of the company. And everybody said, this is hopeless, how can you do that? They participated. There was allegation of fraud against my client. It came before Mr. Justice Andrew Smith. We said this is a question of Indian law, although the contract was governed by English law and agreement, and the arbitration was London. Our argument was that because the contract was entered on the soil of India, Indian law would apply. So I brought in Solicitor, the former Attorney General of India, as my expert evidence. and the other side brought an equally eminent Indian lawyer, Harish Salve. After a 3-day hearing, when they both give evidence, the judge accepted Solicitor Abhi's evidence and the award was set aside. So you see, the judicial supervision is also very, very, very helpful. I'm also now going to just generally speak about my experience as arbitration. Arbitration, when it started, was a quick arbitration. It was not so costly. But after the Big Bang, during Mrs. Thatcher's first reign, the American companies came into legal practice in London, and the arbitration has now become very, very commercialized, and the legal costs are enormous. And that is something which one has to keep in mind. Now I go to the question of enforcement and what should be done about enforcement. There is an issue about enforcement award in India, and I've seen that there are 2 cases where the Supreme Court has given a deferring decision. There's a case of NAFID, where the Supreme Court said that if the award arbitrators have not followed the public policy of India, then the award could be set aside. Now, this is not quite correct, because that's what to follow should be left to the arbitrator. I now come to the post-COVID effect on arbitration. In England, we have started having court hearing on a remote basis. It's not very satisfactory, but it is good. And I think that's how it is to be done. I'm going to come back and share my other experience of international arbitration, and as a person, as a foot soldier working in arbitration. A couple of years ago, again, an Indian case in London, ASM Ship Management Company, where it's a ship case, and my client, broker, Mr. Mustafa, was giving evidence, and the 3 eminent arbitrators, all Queen's Counsel, 2 Maritime arbitrators, 1 Queen's Counsel. And whilst the broker was being cross-examined by the chairman, the broker said, the Greek broker said, Mr. Mustakas, that, sir, why are you asking me? You were involved in it, and you should have known it. None of us got the meaning of it, but 10 minutes later, the third arbitrator, the chairman, said, I must disclose that I had been involved in this case some time ago. And he adjourned. He came back. I asked my client, shall we object? He said, yes, please object. We objected. And this is also a reported case, huh? Ms. Jess. And we objected. The arbitrator said, the chairman said, hey, look, I'm a member of the bar. I'm independent. I'm not going to be affected by it. The client decided that not to go with an immediate challenge. And the Arbitration Act in England requires an immediate challenge, withdraw from the arbitration. We went on, we lost, and we challenged. It came before Mr. Justice Morrison. He found that the third arbitrator had committed misconduct, and he should have resigned, or he should have stepped down. But as we had not followed the law, you can't succeed, and the arbitration award is sought. So the point I'm trying to make is that it's all well and good that the arbitrators, the court must not intervene and court must not supervise. But I have said for 12 years as international court, ICC arbitration, and you occasionally see that there has been unfairness. For example, in many developing countries like Libya in those days, and Egypt, the parties, and also early India, parties to appoint one of their own lawyers as their arbitrator. And that arbitrator, it could be seen, was not able to communicate his views to his colleagues. And this is very important. Even in Indian arbitration, we saw that there was always a dissenting opinion. Now, this is something which one has to be careful. Now, India has changed. India is appointing very distinguished arbitrators. But this is something which also requires to be dealt with on the issue of fairness when you have to look at the international arbitration. With that, unless there's anything else you want me to say, I'm happy to answer the questions. I purposely decided not to go too much into law because Professor Mistelis has already gone into it. But I have given my opinion, and what I've said is my personal experience of having had the benefit of acting for Indian government. And I might just say that the reason I handle over 1,000 international arbitration is when I started my practice, India was going through a famine, and I was appointed as the High Commission, Indian High Commission solicitor, and there were lots and lots of shipping cases because the President Johnson was shipping wheat free of charge in PL 480 and India to charter. and it's been a great experience. I would certainly support arbitration, international arbitration, but one has to be very careful about the cost, ensure that the arbitrators manage to take properly. I will just also share my experience as an arbitrator. And in fact, one of my awards was challenged last year, and it came back to me, and I confirmed it, and again was approved by the court. Very often, there are lots of arbitrators look at the issue of law, but for me, in arbitration, being a commercial arbitration, it's important to look to the ends of justice and the sense of fairness. And that is very, very important. And that's why people appoint an arbitrator. Historically, people appointed the traders as an arbitrator who saw and felt the issues and decided. And again, we are going too much into legalistic quoting. And again, I stress that London has become the seat of international arbitration because of the judicial supervision, and long may that live. Thank you.
Thank you so much, sir. You shared your wonderful experience of arbitration, which is very enlightening for our young lawyers and professionals who have joined us today. So now let's come up to the question answer round. So first question is for Professor Loukas Mistelis from the Dean of CPJ College in Delhi. Her name is Katie Asana. She's asking from you is how the arbitral proceedings shall be terminated by just this question. So,
Okay.
question little incomplete.
I have actually.
Let's give it a second. Yeah. So the dean is asking. Yeah. So the question was incomplete little bit. So I'll ask the question again. So the dean is asking that how arbitration proceedings shall be terminated.
Yes. I have actually looked at all the questions, but I'm happy to take them in whatever order you would like me to take them. On the termination of the arbitration proceedings, we effectively, there are a couple of different technical legal ways of terminating the proceedings. In the majority, one would expect that arbitration proceedings would be terminated by the award, the final award, but you can have a termination of proceedings by settlement of the parties. We can have withdrawal of claims as well, or withdrawal of claimants. Now, the different legal systems take slightly different views as to whether a withdrawal of a claimant or a resignation of a claimant from that position automatically terminates the arbitration process without prejudice. So I think the majority of the cases, what will happen is that the tribunal will hear the parties, will draft one or more awards, and the final award, which will also deal with the cost of the process, will be the formal termination. But we can have termination for any other reasons. Parties not paying the fees to the arbitration, parties find the settlement, which is confirmed through a consent award, or parties reach a settlement, but without a consent award. All of these options are possible.
And so there's a follow-up question from the same person. So she's asking, follow-up question from the same person. Yeah, she's asking how our ADR mechanism is effective in solving the banking and financial disputes.
Yes, this is actually something which has been emerging very much in the last 10 years. Historically, banks did not like to be involved in arbitration or ADR for the very simple reason that either they wanted a very quick and quick decision. They had a debt claim and they were going through a summary proceedings to get an enforcement order, or they did not want to pay for something they had to pay, and then there was no incentive to go to arbitration where things could be much quicker. In the last 10, 20 years, starting primarily from civil law jurisdictions, but now going very much into common law jurisdictions, we see banking and finance disputes going increasingly to arbitration. Some institutions are more popular than others. For example, the LCIA is quite popular for banking and finance disputes. And this expansion of the arbitration process in the banking and financial disputes can be seen also by a very good work that the ICC Commission has done in a working group chaired by Georges Afaki, in looking at these particular matters. And of course, the creation of Prime Finance in The Hague, which is effectively a group of experts which is available to anyone who has a financial or banking dispute to use their services for expert determination, ADR, or arbitration. So it is expanding very much. We've seen in several jurisdictions, banks now started using arbitration clauses or mediation clauses, more arbitration than mediation, I have to say. And we've seen also quite a bit of what is called asymmetrical clauses used by banks. So it's a growing area, and it's actually a very fascinating area of development.
Thank you so much, sir. So now we have a question for Mr. Sarosh Zaiwalla, sir. So there's a participant named Tanushri called. She wanted to ask you how arbitral proceedings is being conducted in this virtual COVID-19 age.
Well, arbitration, like the High Court proceedings are conducted. I have not yet participated in an arbitration hearing, but I presume and I assume that there will be no problem. We had a hearing for a case acting for Bank of Venezuela, and the hearing took place. It was quite satisfactory. We have to get used to it, and I think this is possible to do it on a telephone or on a video. And I think we don't have any option.
Right.
If
so
it continues, the line must move on.
Right. So she also have a follow-up question again for you, sir. How helpful is online mode to manage the overall commercial deals, and is it easy for a client as well?
Online for clients to sort of understand what is going on?
Yes, please. Yeah.
Yes, they can be. It is like any other hearing. But only thing is that we can't see the arbitrator's reaction. For example, when there's a hearing in the court, it is part of advocacy to see judge's reaction. And that is something which may not be possible or may not be so easy. But online hearing can take place and is going to take place.
Right. So we have a third question for you, Mr. Please, Professor Loukas Mistelis from ICSID. He wants to know, arbitration doesn't seem a popular method for domestic disputes resolution. Is it correct to say in the jurisdiction dominant in international arbitration, preferred court systems are domestic arbitration? Like he wants to know whether domestic arbitration are not being so satisfactory in the UK and US, or people choose more of the court dispute mechanism rather than on top of arbitration.
For the UK, I would agree. There are very few domestic arbitration cases, but I think the reason is that the courts are deemed to be very efficient, very quick, and very inexpensive. Perhaps not the commercial court, but certainly the rest of the courts. So if the court system functions very efficiently, and I'm thinking of Germany, I'm thinking of Japan, I'm thinking of the UK, there's no reason to go to domestic arbitration. We have quite a bit of domestic arbitration in countries where the courts are very slow, for example, Italy. And so domestic arbitration and ad hoc arbitration in these cases is not unusual at all. In the US, I'm a bit sort of perplexed because if you look at the statistics of the American Arbitration Association, they announce that they have about 60,000 cases every year, of which only 1,000 is international cases. So in the US, there's quite a bit of a market for arbitration, but a lot of that is actually a consumer arbitration, something that is not popular in Europe or other parts of the world for very good reasons. And I would also discourage people for moving too quickly to consumer arbitration, because there's a lot of interests that you need to protect, and the courts can protect it perhaps a bit better. So the answer to is yes. If the courts are efficient, there's no reason to go to arbitration, and if arbitration sort of can contribute to the court, then that will be in a lot of range of cases. Perhaps one other international example. Slovenia is a jurisdiction where Slovenia is a beautiful small country in Europe of about 2 million people, and at some states they had about 6 million cases in court, which meant every person, including babies, had 3 cases each in front of a court. They have moved to have a judicial mediation and arbitration, and of course they declutter the docket of the courts very quickly. So yes, in these cases, it does work.
Might I take the liberty of adding the reason why international arbitrations are more popular is because there are international parties and they want a neutral forum. And that is the reason why parties agree to a neutral forum like England, Geneva, and others. Whereas, as Professor Mistelis says, in England, the local county courts are much less expensive and very efficient, and therefore people prefer court to the arbitration. And that is one of the principal reasons why parties agree to international arbitration, because they want a neutral forum.
Thank you so much, sir. So we have a question for you, Sarosh sir. What are future prospects of arbitration in India? What needs to be done to make India also an arbitration hub? By Dhruv Singh.
Very important question, and this is a question which I have always been asked. And I've always said that if you want to establish institutional arbitration in India, the change must come from within and not through the parliament and government. The government can pass all laws, but unless there is a strict discipline in the arbitration practitioners to ensure that high standards are maintained, India will not have a successful institutional arbitration center. And there are many reasons for this. Things are changing for the better. There are young people coming in and who have seen how arbitration works in London, Geneva, and Paris, and they are bringing about a change. And there's often a criticism that the judges who are appointed are retired judges, and their appointment becomes this kind of a pension for them, and they conduct the arbitration in the same way. I personally had an experience of an arbitration in Delhi where we came with the evidence. In the morning of the arbitration, within 2 hours, the arbitration was adjourned. Now, this doesn't happen in any international arbitration. I was sitting as an arbitrator in Bombay with Harish Salve and Mr. Justice Evan, who had retired by Lord Justice Evan. And this is a true example. It was a 2 weeks arbitration. Parties had come. And on the 3rd day, my colleague, Mr. Salve, asked the chairman that he wants to take tomorrow off because the Chief Justice of India has asked him to appear to mention a case concerning the airport in Delhi. My chairman said, no, you can't do that because parties have come from all over the world and you can't go. And he was in a state of panic. He talked to me. Ultimately, the chairman gave him a permission. He says, I've got to mention at 10, I'll be finished by 11, I'll be back by 3 o'clock. So he was given the permission, but the chairman said, okay, in that case, we will start the arbitration at 4:30 and continue up to 10:30. And we did that. And we finished the arbitration and the award was published. Now, this is the most important thing which we must keep in mind. Secondly, we find in India, we are still under the colonial approach to law. We must remember that in India, when British were ruling, there were 3,500 or 4,000 white civil servants ruling 400 million. So they wanted to keep the distance and they wanted to keep the pompness and mightiness. And they produced a system in Indian law where we require long pleadings, long affidavits, and it just sort of makes things difficult. So therefore, we lawyers need to change that you don't require long submissions, either in the court or in arbitration. Just be to the point. Now, in England, there is a rule that your points of claim should not be more than 20 pages. Your arguments, your skeleton argument, your written submission should not be more than 10, 15 pages. Now, that has to come from within to make India attractive. Today, when a party agrees to Delhi arbitration, it will go on for years and years and years, and the arbitrator is taking a back seat. Now, that must change. I would not criticize just the retired judges, because some of them are very good, but they must be educated in a polite manner that this is an arbitration, is a commercial arbitration, and one has to take a quick, common sense decision at times.
Thank you so much. That was so wonderful to hear.
India is a center, but it is a long way, and it can only come about if the local practitioners decide to change. There's also a suggestion, and I must be honest, that some of the arbitrators are not as honest as they can be. Now, there, again, the law should not come in, but in England, if that were to happen, everybody will blackball that person. He will not be invited. Nobody will want to talk to him. Now that change must come from within. You young people must bring the change about in India, not
Sure,
just
sir,
by law.
definitely. Sure, sir. Thank you so much. So, Professor Mistelis, we have another student who was 2008 pass out, Anand Khannan. He's an advocate on record right now at Supreme Court of India. He wants to ask you, common law country like India, is it high time we also apply other applicable laws in Indian arbitration, like arbitration in Switzerland?
Interesting question. I find sometimes when I sit in London as an arbitrator with English arbitrators, often former judges, that their flexibility in terms of application of foreign law is leaves to be desired. In what sense? I mean, everyone, because of legal training, has a bit of baggage. So the baggage of the jurisdiction we have studied first. So you inevitably people try to translate what they hear, which might be the applicable law in German or Italian or Greek or whatever. So you try to use English terms in order to get to the bottom of what the other party is communicating. Of course, if you want to be an international hub, you have to have the flexibility of allowing sort of other systems to come through, and you have a good enough arbitration bar in terms of counsel and arbitrators will be reasonably well versed in comparative law, and I think that's critical. I have to say, because that's one of the questions about places developing, and one of the questions was related to Dubai. One of the reasons why Dubai is growing is because Dubai is becoming a melting pot. If you go to an arbitration event in Dubai, there will be lawyers who are from France, from Australia, from New Zealand, from India, from the UK, from the US. So creating that melting pot and allowing non-locally qualified lawyers to practice is what makes that jurisdiction open enough to arbitration well. Because if you have to hire a local counsel on the top of the lawyer you wanted to have, that automatically creates a problem. And this has been one of the issues about arbitration in India. I only had one case in India. I was chairing a tribunal with an Indian former judge and an arbitrator from another jurisdiction. And we were very concerned as to whether we need to file tax return in India for the work we're going to do, that the law was requiring that we complete the arbitration process in a particular given time frame, which the judge, co-arbitrator, was quite reassuring that we can extend and the application to the court shouldn't be a problem, but you need to create that openness to the system. I think that's critical.
May I also take the liberty, Professor, of just adding that one of the reasons why the problem which is posed, because in England, if foreign law is to be applied, the general practice is that foreign law is a question of fact, and therefore it has to be proved by a foreign lawyer, and that's only fair. So similarly in India, technically there's no restraint because arbitration contract is by consent, and parties can provide, they say for Delhi arbitration, that French law must apply. But then the French law will have to be proved, and there must be a system by which both the arbitrators and all the parties understand what the French law is. So that creates a little more complication to proving foreign law by fact.
Right. So, sir, we have a question for you, Sarosh, sir, from Piyush Yadav. He says, can an arbitration award issued by a tribunal in the United States or a foreign country be enforced through US courts against the assets located within or outside of the United States?
Yes, of course. There is a process in the United States. The United States court is also very different from the English and the common law jurisdiction court. And the legal system is very different. So it can be a long drawn out process. I know that I have made an arbitration award sitting with Bruce Harris, one of the Nigerian arbitrator, against the Nigerian government. And I know that that award is now 7 years old, and it is in the US courts with various appeals. So it is difficult, but it can.
Right. So thank you so much, sir. This was our last question for the day.
Govind, I would like to ask one or two questions to Sarosh, sir.
Yeah, sure, please.
Sarosh, sir, as you mentioned about enforcement of an arbitral award in India, and you mentioned that NAFED judgment. So what are your views that what steps can be taken in India to improve and make more acceptable towards enforcement of foreign arbitral awards? Like what steps the court should be taken or legislative steps should be taken towards that?
First of all, the NAFED judgment, which I consider unfortunate, because although the Supreme Court judges said there's an issue of public policy, and what had happened in NAFED was the government order stopping the export of the commodity. But what appears to have been overlooked, that the respondent was also a government-owned company. Now, if I was a judge, I would have said, okay, look, this is not a third party. We were both part of the common ownership, and therefore it is unfair to bring a defense of public policy, and that's the reason why the NAFED judgment went against the successful plea. What we need to do is to have a special bench of commercial court in the Supreme Court and in the High Court, where there are judges who are experienced in arbitration. I've said this many times at the conferences, and like we have it in London. We have a commercial court and the judges are all experienced in international arbitration. They're all practitioners. So if we can have a special judge with selected judges, commercial experience, and who can sort of feel and sense that justice requires that the arbitration award should be enforced. And that is the first thing which that should happen.
Thank you so much. Follow-up question,
yes.
Sir. That on the issue of investment disputes that are prevalent in India, where companies are involved, government institutions are involved, and foreign companies are involved. So the Indian government is usually reluctant to go for arbitration in such cases, fearing that the officials, the arbitrator will not be favoring them, or there will be a bias against them, and they prefer courts for their dispute resolution. So what are your thoughts? What should be done towards it?
Now, if there is an arbitration agreement as a result of the investment treaty, then Indian government is bound by it, unless it can be said that the investment treaty is not binding. And I was going to say, and I forgot about it, when I said I'm going to refer to the UCOS case. The UCOS case, after there was an award of $50 billion against the Russian Federation, they went to top English-American firms and said, you can't do anything, you participated 5 years. Then they came to me, because we have acted for Russia from time to time. And then I appointed Professor Vandenberg. And the point we took was the same point which we took in the PEC versus Asia Golden. And the point was that although the investment treaty was signed by the Prime Minister of Russia, the Russian law required the investment treaty to be ratified by the parliament, which had not been done. On that basis, the first challenge in the Dutch court was successful, and the appeal they have lost now is before the Supreme Court. So therefore, if there is an investment treaty which provides for arbitration, I think an Indian government does not have the option to go to the court and say the court must decide and not the arbitrators.
Thank you, sir. Yeah, go on.
Like, I have a last question from my side. Like, it is a very interesting one. So what is the future of third-party funding in an international arbitration in India, especially?
Very interesting. In fact, there was a recent judgment in an arbitration case where the English Court of Appeal said that that third-party funding was unlawful. But third-party funding has changed the scope of litigation and arbitration is going to be. It is fair that if a claimant doesn't have the money, he does require third-party funding. But the third-party funders would want to make sure there is more than 50% chance of success. And they would take at least 15 or 30% of the things. So it is something which is developing in England in litigation. It's very, very common. In the arbitration, I don't see why not, but there must be a sense of fairness. I don't know whether it has come in India yet, but it is a big business, and it's a very growing business for people who have funds to form trust and do third-party funding.
If I may add,
I would like to view on it.
If I may add, because there were quite a number of questions about third-party funding, about SR and other cases. I speak to third-party funders from time to time. I think the reality is that third-party funding is here to stay. And there have been a lot of attempts to introduce different levels of regulation to get it to where parties would be more comfortable and where arbitrators and judges will be more comfortable. But the reality at the moment, and given the current coronavirus pandemic, it appears to me that third-party funders sustain firms that cannot be paid by litigants directly because they cannot afford to divert money to a litigation rather than sort of keeping people afloat and keeping business go. So I think third-party funding is, to the extent that it's already very well used in different formats of litigation, I think arbitration is an extension to it, and I see that growing rather than going down. What I see also as well happening is much more scrutiny and much more sort of critique about practices, so that I see more and more third-party funders preparing to take now smaller cases, so that they effectively provide some platform for access to justice, because so far that's not the formula they have used. They have been investors in claims rather than facilitators of access to justice.
Thank you so much. Thank you so much, both of the professor and the Sarosh Zaiwalla sir. So this brings end to the questionnaire round of ours, and we would like to thank all our viewers and our distinguished panelists who have joined us today and taken out their time from their busy schedule. Thank you so much. Thank you, Latest Laws.
Thank you, Govind. I would like to thank our supporters for today's webinar, Society of Construction Law India, Indian Dispute Resolution Center, M.K. Gehlot and Associates, North Cap University and Ansal University for providing their support. I would like to thank our esteemed panelists and viewers on behalf of Managing Editor of LatestLaws.com and team. With this, I would like to wrap up this session. Stay at home, stay safe. Thank you. Thank you, Sarosh. Thank you, Loukas, sir, for joining us. Thank you so much. Thank you, Govind.
Thank you.
Thank you for inviting.
Thank you.